Good evening, everyone. Welcome to our special council meeting of July the 29th. Before we start, anybody has a ball cap on, please remove in chambers. Thank you. Dean, call the order, please.
Mover and seconder, please.
Jennifer and Betty.
Moved by Councillor Gauthier, second by Councillor King, that the special council meeting of July 29, 2026 be called to order at 4:30.
All in favor? Carried. Roll call, Dean, please.
Mayor Bennett,
Present?
Reeve Watt,
Present.
Councillor Gauthier,
Present.
Councillor Hewitt,
Present.
Councillor Hughley,
Present.
Councillor King,
Present.
Councillor Wren.
Present.
All members present.
Thank you. Confirmation of the agenda. Alan and Wendy.
Moved by Councillor Wren, seconded by Councillor Hewitt, that the agenda of the special council meeting of July 29, 2026 be approved as presented.
All in favor? Carried. Delegation.
No, I think we're gonna.
Oh, we're going to
Yeah,
change?
yeah.
Okay, so we're going to move the agenda around a little bit, and we're going to start off with the planning public meeting. So before we do that, declaration of recurring interest and general nature thereof. See none. Motion to open up the public plan meeting. Brian and Alan.
Moved by Councillor Hughley, second by Councillor Wren, that the Council of Township of Laurentian Valley pursuant to Section 17, 22, 34, and 36 of the Planning Act hereby declare a public meeting open at 4:30 p.m. to discuss application for zoning bylaw and file amendment Z 2026-10 Lubitz, consent B2525, application for zoning bylaw file number Z 2026-11 Gade, application for zoning official plan amendment file number 0226 03 additional consent criteria OPA 23.
All in favor? Carried. Okay, Laurie, turn it over to you for Lubitz.
Okay, so the first application for zoning bylaw amendment we have before us tonight is file number Z 2026-10. So notice was given in accordance with the requirements of the Planning Act, and it was a combined notice of application and of this public meeting. So the description for this is that the purpose and effect of the amendment is to rezone a proposed retained agricultural lot to prohibit residential uses in order to meet a condition of consent for County of Renfrew Land Division Committee application for consent, file number B25/25. So the proposed severed lot is occupied by an existing residential dwelling, 620 Forest Lee Road. The rezoning is required as the subject lands are comprised of Class 2 and 3 soils per the Canada Land Inventory and therefore are considered to be in prime agricultural area, CLI Class 1, 2, or 3 soils, per the provincial planning statement, and have been designated also as agriculture on Schedule B, Map 5 to the County of Renfrew official plan. So in accordance with the PPS, severances from prime agricultural lands are only permitted for surplus farm dwellings, and therefore the retained will be prohibited from residential use. The effect of the amendment is to establish a rural exception 99 zone with a special provision to prohibit residential uses and to rezone the proposed retained lot from rural to rural exception 99. Again, the lands affected by the amendment are part of lands currently known as 620 Forest Lee Road, which is also County Road number 42. And the map showing on the screen is the location of the lands. And again, within Part Lot 27 and Part Lot 28, Concession 15, Geographic Township of Alice. Again, copies of the information supporting the application are available at the Township office. Anybody wishing to speak to the file can participate either by providing written or verbal comments, either support or opposition to the proposed amendment. In terms of the, there is more limited ability for appeal to the OLT, but in order to preserve any possibilities to be added on, as a party, you do need to make comments prior to a decision being made. And again, if you wish to be notified of a decision of the township on the proposed amendment, you need to provide a written request, and there's also a sign-in sheet available here before you leave if you wish to sign in. Again, all applications for Planning Act approvals are part of a public process, and as such, by providing your comments, you're giving us permission to potentially release that information, including your name, number, address, that are all forming part of the public record, that we can share that with the people requesting that information. Okay, so in terms of this application, we didn't receive any written comments from members of the public. We did receive our usual no comment or concern letters from some public bodies, but the main one that we did receive a comment letter from that we have shared as well is the Trans-Canada Pipeline as the property. If you're looking on the map on the wall, there's a purple dash line along the far edge. That is the Trans-Canada Pipeline. And so just, again, it's a reminder of activities that can't occur in proximity to that. And should there be a change in property ownership that transfers on, there usually are things registered on title as well, but they just wanted to reaffirm that.
Okay. Any questions from council? Seeing none, do we have anybody on the line for this one? No?
Yes, so it
Okay.
does not appear to be anybody on the line. The deputy clerk has confirmed.
Okay. Anybody from the public wishes to speak on this item?
I can speak on it. I'm the actual applicant. I don't know if you want to hear from me at all.
It's up to you, sure. But if you, can we get you up to the front on the crutches, or?
Yeah, sure. Sure.
I know what you just said, but when you get to the mic and you're ready, just say who you are and your address, please.
Yeah. Hi, I'm Matthew Lubitz. I live at 620 Forest Lee Road, Pembroke, Ontario, the one on the application you guys are looking at right now. Basically, we're trying to sever the property so my wife and I can live on it. I bought the property when I was 24 with my parents, and when I started doing wills and stuff, we figured out some things didn't work, so severing was a way to solve some issues we were having with the property with my co-ownership with my parents. So it was just the compromise we made. That's
Okay,
the purpose
that's
why
great.
we're doing it.
There's a recommendation of our planner to approve it tonight, so.
Thank you.
Thank you.
That's all I had to say.
Okay. Mover and seconder, please. Brian, Alan?
Moved by Councilor Yulee, second by Councilor Wren, that the council supports the approval of our application for zoning bylaw amendment, file Z 2026-10, Lubitz, B 2525, and recommends that council approve the bylaw 2026-07031 as presented and forwarded to the bylaw portion of the special council meeting of July 29, 2026 for enactment.
All in favor? Carried. Okay, Laurie, our second item is the zoning bylaw for Agata.
Yes, so our second application tonight, it's file number Z 2026-11. And again, it was also issued as a combined notice of application and of this public meeting. And the notices were issued in accordance with the requirements of the Planning Act. The purpose and effect of the zoning bylaw amendment is to rezone the lands to permit a second dwelling unit in an existing garage structure to be converted for the use. And it's on a property occupied by an existing single detached dwelling that at one time was an accessory dwelling to a commercial use in another existing outbuilding on the property. So the current zoning only permits one accessory single detached dwelling, and as there is no current commercial use, the existing dwelling is considered legal nonconforming. So then the effect of the amendment is to revise the existing exception zone provision with a new general commercial exception 4 zone provision that has an exception that also permits a second detached dwelling unit within an existing structure abutting the existing dwelling known as 607 Bank Street, and recognizes also the existing dwelling. The provisions will also specify that no open outdoor storage permitted in the front yard, and that a minimum 60 square meter outdoor amenity area must be retained in the backyard as a designated outdoor space intended for the recreational, social, and physical enjoyments of occupants of the dwellings. The existing performance standards for the location of the buildings will also be recognized in the zone provisions. It is noted that there's no existing operating commercial business on the property. The current GCE4 exception provision also allows an automobile repair shop. No change is being proposed to that provision, so that's carried forward. Any future proposal, though, to establish a business on the property would have to be in compliance with all applicable provisions of the general commercial zone and the comprehensive zoning bylaw, and may require a site plan and such other matters to be addressed as required by township bylaws or policies applicable at that time. The lands affected by the amendment are known municipally as 607 Bank Street, and it's Lot 18, Plan 402 in the geographic township of Stafford. Again, information related to the application is available at the township office for viewing and was made available to anybody coming into the office and requesting such. Again, this is a public meeting, and all information, including names, comments, addresses, emails that are provided as part of the public record form part of the public record and may just be disclosed. And by providing them, you are consenting to them being disclosed to anybody as required as part of the planning process. And again, anybody can make a comment or either verbally or provide in writing, either in support of or objection to the application. And although appeal rights are more limited, you still need to make any comments made aware prior to the decision to maintain any possibilities of those rights. So in terms of comments, we had not received written comments prior to the issuance of my report to council. I did receive a written comment that I did circulate to council just prior to this meeting. My understanding is that the person has some visual impairment, making it more difficult to read this out to council during the meeting. So there has been a request that another person who will providing comments, if they could possibly read that, or if council wishes to read that in their own time, that's the option as well.
Okay. Questions of council? Keith, sorry.
I noticed that in there it said a tarpaulin shelter was to be removed. I didn't see it when I drove by. Perhaps it was already gone, or is it in the back portion where maybe I couldn't see it?
It is on the front and in the front right corner. And when I had earlier today, it was still up there. So it's on the, if you're facing the property, it was on the far right corner.
So it is still going to be removed?
Well, I guess, Keith, what we have to look at is, in Laurie's comments, it was previously noted that there's the garage that is to be removed to bring the property into compliance. So as far as I'm concerned, the property is not in compliance right now. Therefore, I would recommend that we defer it until it is down to our next meeting. I don't know how council feels on that, but. Now, that being said, Laura, I'm not sure, do we continue with the public meeting, or?
Yes, I think the thing is you still continue with the public meeting, and then after all comments are received, then council can discuss the motion.
Okay. All right. Alan?
There has been ample warnings to have that structure removed, and they've had ample time to remove it, is
I believe
my
so, Laurie.
understanding.
That's correct? Oh, okay. Sorry, just hang on, folks.
Say, I would defer to, I believe, is our chief building official?
No.
Well, he's in
Behind-
his
oh.
office, I can get him if he
Oh,
needs
okay,
to.
because I thought he was coming back in.
But I do understand from
Yes.
our, that they had warning and ample time to take it down.
Yes, our chief building official, also by law enforcement, had provided that request
Yes.
of information.
Okay, so with that being said, do we have anybody online for this? No? Anybody from the public wish to speak?
I think we got somebody from
Okay,
online.
Oh, we
yes.
have
So our,
somebody?
our deputy clerk is just confirming that there may be
okay.
somebody online. So if there is somebody online wishing to speak to this application, if they could please raise their hand with the signal on Zoom. I would just confirm with our deputy clerk, is it a phone or is it a virtual? Okay. I believe it's. Okay.
Oh, okay.
Okay. Okay, so as we're not seeing a hand raised, we believe it might be for another matter, so we can now move to those within the
Okay.
room, Mayor.
Does anybody wish to speak? And if you do, I would ask that you keep it to the planning issue on hand that's being brought forward tonight. Please come to the front, state your name and address, please.
Hello, Town Council. My name is Nathaniel Peart. I am a resident at 605 Bank Street, the adjacent property to the one that we are here talking today. I will shorten what I have written here to be as succinct as possible. My family has resided beside the property in question for over 2 decades. The previous owners, the Maves family, were staples of our community. Whether it was his repair shop or later plumbing business or her craft shop, they've always been a member and contributing to our community until they retired and eventually passed away. Since that time, the property has, of course, changed hands, and we've lost a commercial section in our community as none has returned from here. And that's what brings us today to the garage, which is currently already inhabited by tenants. I do question if this is in the spirit of the general commercial zoning for our official plan for Laurentian Valley. It seems to me that this is more of a residential use, even as indicated on the application. We do know that it is, the existing house is legal non-conforming, and we are asking for an additional legal non-conforming building here. And I do question the motive behind retaining the commercial zoning and adding an additional residential. I do wish to encourage people to remember what the spirit of legal nonconforming is that it's a structure intended to protect existing buildings until they naturally cease, and not a mechanism or license to intensify or add to an incompatible use. I do also want to bring out the definition of whether or not the building is considered attached versus not. The building, as per the bylaws, it has to have a structural wall for it to be considered attached. It does not. It only has an overhang between the house and the garage, so it really is a separate building. And as a detached building, it does fall under the 65 square meters that is required for a detached residential unit, as indicated on the application. I do also wonder if, before the inhabitants had moved in, if the appropriate permits were created and granted for this unit. It seems to be that there is a circumvention of our bylaws that are applying here. And it is very discouraging as a member of this community for over 2 decades to see something like this happening. I do also want to point out, as part of the Planning Act for the notification, there is supposed to be 20 days of a sign being posted. Now, this is to no fault of the municipality staff, nor the applicant directly, but rather the tenants within, that sign had been removed for 4 out of those 20 days. And I would suggest that this be deferred until the full 20 days is there, so that there is no appeal on that regard. I do also wish that the community is aware of our council supporting of our bylaws here, and I wish that our council supports our community in this election year in demonstrating a compliance with our bylaws and the spirit behind them.
Thank you. So Laurie, do we want to try and answer some of those questions tonight?
Certainly, like in terms of the designation of the property in the township official plan is residential, so the residential designation does permit that primarily as the use. So in terms of having the additional a residential unit, per the OP, it does meet the official plan requirement. So from that perspective, and again, in terms of the legal nonconforming, the reason we're recognizing that existing dwelling, because technically it would have been, when the commercial use was there, an accessory residential dwelling. So it's just, again, acknowledging that without that, it is technically considered legal nonconforming. But then for the second unit, it will be brought in as a permission within that exception zone. In terms of the attached versus not attached, in conversation with the chief building official, it is technically a detached structure because they're not fully attached, and so that's where the minimum dwelling unit area would have to be met, but it's also based on number of bedrooms and size, and so that will all have to be made to conform with the building permit when that is issued, assuming that the permissions are granted. So again, there has been no building permits issued for that second unit, and that's what brought this forward to be the application for zoning bylaw amendment, seeking for those approvals to legitimize that.
And maybe to comment on one of your, sorry, just till we're done. Certain things happen within the municipality that we're not aware of. Not everybody is completely upfront on how they operate, a business or a residence, whatever. So we act on complaints in most cases. So once we were made aware that there were people in the garage, then the municipality stepped forward and contacted the owner to tell him, you know, we need to conform to the rules of the municipality. To get a building permit, you need to go through this zoning bylaw amendment. So it doesn't happen overnight. Laurie talked to the owner, said that the process was going to happen. It took some time, the summertime, for council meetings, etc. We didn't want to see anybody moved out onto a street. So we allowed the owner time to follow the rules of the bylaw enforcement officer on his multiple visits. So that is why we allow the people to stay in the building until today, until this is solved, and eventually a building permit may get issued. So that was to answer that question. As far as the 20 days notice, I know that we did have an issue with someone taking down the sign numerous times. We can only control the sign put up certain times of the day, and when it disappears and we're aware it's gone, we do put it back up again. As you made aware tonight, it was taken down 4 times. It sounds like this is going to be deferred anyways, so I'm sure we'll be outside the 21 days at that point. Did we answer your questions?
I think so.
Okay. Somebody else had their hand up. Please come to the front.
Hello, my name is Michelle Butler. I reside at 609 Bank Street. 2 things that came up just now is I don't understand how, I don't want anyone kicked out, obviously, but how is this person that owns this building, that made the garage into a building, able to turn it into one a year for almost 2 years, then go after the permits he needs, how he gets away with that. The other one is, as of 4 o'clock, I was taking pictures and nothing was taken down from the front of that yard at all, including the 10-foot fence that was put up in the backyard. And this garage leans on our fencing. So this has been here for over 2 years, and
So the
a
fencing,
year and a half with the fencing and everything, almost 2 years. But the garage has been there forever since he took the property. How does a person get away with building something, then saying, well, you know, I can say sorry later? I'd like to know that.
I can't speak on someone else's behalf, but we act on complaints.
Well, we were told, when we called, we spoke with Mr. Miller, and we were told that they let it slide. and that they finally came in to get the papers they needed a couple of months ago. So that should be told to everybody in the neighborhood what is going on. Not once did we see a permit in any window. And the other thing about this building is, as a personally, I'm thinking, it's a building that has a garage, 2 windows in the front, a door in the front, and no other windows in the building. How does somebody get out of a fire in that building? How safe is that?
Okay, so Mr. Miller is our bylaw
Yeah,
enforcement.
he's at the door, I think. Brad, are you
Brad?
there? Yeah. Yeah. Oh, I thought he was coming.
It really bothers me about the fire because we had a house fire and we know what it's like, and we were able to get out. But nobody's going to be able to get out of that building if they're not in the front door. That is not safe.
Okay, I can't answer that, so I know Brad is working late tonight, so I don't know if he's able to speak to it, but we will address it
Okay.
as per part of the open meeting. I was not aware they were living there for 2 years before.
A year and a
they acted
half
on it,
at
but-
least. It's been a year and a half at least.
Al,
So some of your concerns will be addressed when they get a building permit, and they will have to get a building permit for that residence. And those issues then will be addressed at the building permit.
Another question is, if this goes through and he has 2 dwellings on that and it's a residential area, can he put another building back there to make apartments or whatever else? We were told no, but I'd like to know, can that be done? I don't want anything slipped behind us again.
okay, go ahead.
So just prior to our chief building official
Okay.
speaking to the other issue, I can just clarify with regard to the number of residential units. So because this is still a commercial zoning, again, it's only allowing the second dwelling unit. So it's different than the other areas of that neighborhood where if it has a residential zoning, there's the possibility of, with the additional dwelling unit policies of the province for up to 3 with different formats. That's not something that applies here because it is a commercial zoned
So
property.
your answer is no.
So just 2.
Okay, because there have been over 3 different people who have rented that garage in the last year and a half. Not one person, 3 different people have been in and out of there.
Okay, Brett, could you answer, maybe repeat your question on the fire issue, if you would?
The garage has 2 windows in the front and a door in the front. No other windows or doors are in that building. How does a person get out of there in a fire, and how is that passed as legal?
So it's exactly answered your own question. There is a door and there are 2 egress windows. There's a minimum size for those windows. They have to be openable without the use of special tools. And other than that, it meets building code requirements. You only need 2 exits, and they have technically 3, so.
So would you like to be in this garage, sir, at the back of this garage
Okay,
with a
ma'am,
fire?
I'm sorry,
No.
but that is not a
That
bylaw
is-
that we created. It's a provincial bylaw, it's a building bylaw, so.
It's just
he's
not
answered your-
morally right.
You know what?
Yes,
I
sorry.
totally understand, but we have to follow the guidelines of the
I
building
understand.
permit. So we're following
I
that.
think something needs to change then. Thank you.
Okay, thank you. Anybody else wish to speak? Okay, are we going to deal with this letter that we got, or is it for information for now?
Information. I guess if we're leaning to a deferral, then we can certainly put it as part of the mandate, and Lori can reconvene unless there's a question on it you want clarified, Lori. I don't think there is at this point, really.
I think the only question might be, so I believe it was the first speaker that provided that to me on behalf
Oh, I see, okay.
on behalf of his mother, who wasn't able to read this. But I just guess my only question would be, is there anything that's different out of there that's more specific that just wanted to draw the attention to rather than reading the whole letter out loud at this point? I mean, again, council will have that for consideration as well.
Okay. Brett, one of the other questions brought up tonight, other than the garage in the back, was there a fence that is infringing on the neighbor's property? Have you seen that, or could we just leave that till we defer it and look at the next meeting, or can you make a comment to it now?
I'm not sure what, if anything, we can do about fencing, unless it's regarding security of a privately owned pool. We don't have a fence bylaw, so it always falls under civil. So if there's a dispute about a property line, something like that, we're not involved. It's a civil between the neighbors. If anyone's phoned in the past about a fence, I try to use the same wording all the time and tell them that because we don't have a fence bylaw other than for pools, be very aware of where the property line is. Obviously try to talk to the neighbors if you can. A fence does not give the right to trespass. So think about what type is going up and whether you can perform the maintenance from your side. And other than that, call before you dig. And if there's if it may encroach on a roadway or an intersection, contact the road authorities to see if they have any more guidelines, because sometimes there are maximum heights, etc. But other than that, we don't have the tools. We don't have surveys. We have no way of knowing where property lines are, so it's up to the courts to decide.
Okay, thank you. Okay. We have
I guess the question, maybe we could ask the applicant, has the tarpaulin garage been removed?
come to the mic.
Maybe
if you
come
would.
to the mic, please.
It was underway today. There were some bigger things inside there that we had to move. Snow blower, some bigger things. I offered my services with the tenant. She doesn't have anywhere to put this stuff. But she assured me by Friday, everything will be removed.
So the answer to the question is no?
Not yet.
Not yet.
It's in progress. I will say that. So yeah, I guess no is the answer, but it is underway.
Okay.
So
Unfortunately, we have to follow the rules, and I'm sure you understand. Come to the front, please.
So there is an
No,
issue. Sorry, my name is Sarah McKenzie. I live at 548 Boundary Road. There was an issue before with the fencing issue. Now, they have the fence on the one side that we apparently can't do anything about, but the lady on the other side wants to put up a fence because their animals are always coming into their yard.
Right.
So what do we need to do to solve this problem? There has to be something.
Yeah, I think.
Like, it can't just be left up to the neighbors, because then the cops were called. Yeah, like the cops are
Okay.
in our neighborhood all the time.
I understand that. I do.
Yeah.
I'm well aware, but Brett, can you elaborate on that, please?
I mean, if neither property has a survey and there's a dispute about the property line, unfortunately, they have to solve that. Like, we don't have.
Can they go, can't really get another survey at this point,
Well, you
right?
could. I mean, you could
Well,
hire a surveyor.
I
I think
mean,
the key here is the fence can be put up. Nobody's saying you can't put a fence up. But as Brett mentioned, is that the fence, you need to identify your property line. Because what happens is, if the fence is put up and then the other party finds out it's on their property, they're gonna take it down, and they have the right to take it down.
Okay, so the issue is that where the dwelling that is in question, the garage, if they put their fence up, that's right in a like driveway scenario. So that's gonna go halfway through the driveway, which means they have no access to their backyard by vehicle. So that's why they have an issue with it.
Yeah.
I mean,
So there has to be a way that we can solve this somehow. And if there isn't, then maybe that needs to be considered.
I mean, for residential properties, you don't need to be able to get a vehicle to the backyard.
Yeah.
There's a lot of places that are, 1 meter, meter and a half.
Yeah, and I'm not saying that that's the reason why
No.
it
no,
shouldn't
yeah.
be approved. I'm saying that's a reason why they don't want it done.
Yeah, so I would suggest you get a survey done.
Okay.
Yeah, and
The only way that's gonna be 100% sure, you put the fence on your own property.
Okay.
to try and, reduce the costs, you can ask for a survey just of that lot line, if that's all that's in dispute.
Yep.
Unfortunately, it is still going to cost, but it won't be as much as a full survey.
Okay, thank you.
Okay. Yep. Come ahead, Mr. Dada.
Just a slight matter, what she was just talking about with the access to the backyard. There was an attempt to install a fence to basically negate the access to the back. That access, over the years that I've been there, there's hydro lines that cross the river at the back. I've seen hydro with their bucket truck at the back of that property. With the fence there, they would no longer be able to access that backyard to potentially service the lines. So I just want to make sure everybody's aware of that. As you might be able to see it there on the picture too. So it's a little more, and we've also had there was a power line, there was a fire with the trees touching those power lines that are crossing through over the river. And the fire department was also down there last year, and they cut all the trees down to basically clean up the area. So it's a little more than just the access just to go to the back for personal reasons. There is a little bit more to it than that too. So I just want to make sure that was brought up and aware.
So the person that wants to put the fence up and is going to get the survey may want to contact Hydro as well
Yep.
at the same time?
Yep.
To get all those issues solved before you move forward. Okay. And,
Laurie's got a comment.
Aye.
Laurie had one there too.
Laurie?
Yeah, and I think should there be any resurrection of a commercial use that is, again, on that property, it would require a site plan that would require a survey and having to demonstrate the access. So, whether that, if there's any kind of future thoughts, that may be another reason perhaps to discuss the possibility of establishing where actually that lot line is.
Okay, so if you want to maybe come in and see Laurie or Brett, one day this week or whenever is convenient for everybody, you could sit down and get all the suggestions from the staff as to how to move forward. That's best for you.
Thank you.
Okay, gentleman in the second row had your hand up for a while.
Sorry.
Yeah, you have to come up to the front, sir. Sorry. Just state your name and address, please.
Will do. My name's Bob Butler. I live at 609 Bank Street. I was going to refer to about this fence, if Brett's going to be talking about it, kind of stuff. Maybe it'll be fixed up at a later date. I did talk to Brent a month ago about the fence issue, and he said Laurentian Valley has no bylaw with that. The fence, there was an attempt to put the fence in, and apparently the neighbors disrupted that process.
Right.
In I would call it illegal manner. As of now, for Hydro to return, or to get to the back of that property, go back with chainsaws. You carry chainsaw long piece, you don't need vehicles. Right now, for that landowner to get to the back of that property, with the existing fence that's along the side of, I think, is it 605 Bank Street? There's an existing fence at the back there. That line is obvious. Out near the driveways, there is an old existing post there in the ground where an old fence has been, obviously. Like this, these surveys are pricey. Right now, it's an obvious trespass by 607 Bank Street to get back there. It's an obvious trespass against Nathan's property back there.
And I really appreciate, Councilor appreciates information on the fencing. Again, we can't control that.
I
All we're
understand.
doing is giving suggestions for the owners to get all the information before they put a stick in the ground.
Yeah, just for like, the obvious vehicle trespass, they're well off their land. And the dog issues, there's been dog issues there for a year. And this elderly lady, Nathan's mother, wants a little bit of protection there to put a fence in. She should be entitled to that without $1,000 of survey. It's ludicrous that she's got to get a survey to put a fence in for her own safety and keep people off her property.
Totally get it. I totally get it, but got to follow the rules, unfortunately.
You just got to be sure you're on the property line. That's the key. If somebody's sure, then you can act on that on your behalf. But if you're not sure,
Well,
the problem, even if I understand you're going to say the post looks like it was there, but maybe it was always in the wrong spot. we don't know and we're not getting involved. It will come down to, you know, if the person puts the fence up and then the other person goes and gets a survey and finds out the fence isn't on their property, the fence is, they have the right to take it down.
A measurement of the frontage should be able to
Well,
take that in and,
again, a survey, we always say a survey, because obviously they're doing, you know, they're professionals, they put the pins in the ground, everything.
I got it.
There's no reaction to that. I understand what you're saying, Bob, I understand 100%. You can kind of measure it out, and you're probably close when you do that. But is it legal till the surveys come? It's probably not, you know, not official.
not horseshoes, is it?
Well, that's what we're trying to cure here.
Yeah. Thank you.
Okay, thank you, Mr. Butler. Okay, I'm going to take one more if I can.
The lady in the back corner, did she ever?
I have the lady in the back corner and I have Mr. Goddard, so we'll do the lady in the back corner and then. Just state your name and address, please.
You can bring it up.
My name is Lynn Rancourt, and I just want to clarify something. Now, if the property is commercial right now, they're asking for residential to be able to add another place too, correct? What happens with the commercial at the back? If they decide they want that commercialized later on, do they need to put up a fence?
Laura?
So in terms of, if there is a proposal for a commercial use to be reinstated in the future, that's where whatever bylaws are in place at that time would have to be complied with, and there could be situations where buffering is required, but that could be a fence, that could be a hedge, there might be different things, but we'd have to assess that at that time. But there is no current proposal right before us for that, like for any commercial use.
But the way things have been happening so far, everything's done after the fact. So what's going to happen if the commercial property is being used as a commercial property even before it was ever
As
approved?
soon as municipality is advised, we'll act on it.
Okay, well, thank you. That's all
Can
I
we-
wanted to
Can we
know.
just get your address, please?
Oh,
For the
yes, 635 Weston.
Okay, thank
Okay,
you.
thank you.
Mr. Goddard? Name and address.
Yeah, I'm Reed Goddard. I'm a resident of Laurentian Valley. Curtis is my son, and there's been a lot of talk about this fence, and I'm a realtor, and I have a little bit of experience regarding that stuff. Now, when Curtis purchased it, there was a historical right-of-way to the back of that property that the previous owner used for many, many years. As the other fellow was saying, you know, they've always been trespassing. Well, there's such a thing as a historical right-of-way that has gone back forever, however long that property's been there. People have been driving in there. And the issue we have about this fence is it would just cut off the access for more or less no reason. And these people here are assuming this is their property line. And we're prepared to go to court with this, simply because a historical right-of-way is a right-of-way. That they can't just say, well, I'm putting a fence up here today, or I'm not granting you access. No, it doesn't work like that. But anyway, that's what I just wanted to say.
Okay, thank you. Okay, so.
I guess at this point, we're gonna defer it, yeah. Yes, we're deferring. We'll defer it based on tarpaulin garage. Yeah.
Okay.
Okay, we had a motion.
Alan, Betty?
Moved by Counselor Wren, second by Counselor King, that council defers the decision on applications for zoning bylaw amendment file number Z 2026-11, got a pending confirmation that the non-compliant tarpaulin garage has been removed, and council has evaluated comments received tonight.
All in favor? Great. Thank you, folks, for your patience. Okay, Laurie, move on to item 3, official plan amendment.
Okay, so the next application that's before council is this is the council-initiated amendment to the Township of Laurentian Valley official plan, being official plan amendment number 23. Sorry. So notice was issued in accordance with the requirements of the Planning Act. Now, this was a first of a situation, as it was the first time we weren't able to use the Pembroke Observer for a township-wide amendment, so it was posted in accordance with the new alternative procedures provided for under the Planning Act, which was to post it on the township website. We did also create a posting board as people come into the township office that does have all our Planning Act notices now as well for those people who don't necessarily have access to the internet or online, and that we'll continue with that process coming forward as well as a courtesy. So again, it was given in accordance with the requirements of the Planning Act, and it's under Section 17 and 21 of the Planning Act. And again, it was OPA number 23, file 0-2026-03. Again, a key map wasn't provided as this affects the entire township, and information was available at the township office for viewing or reviewing upon request. The purpose of the proposed amendment is to amend Section 18, Land Division Policies, to introduce additional criteria to guide the evaluation of any future consent applications, and to allow for the potential for up to 3 additional lots beyond the current policy of no more than 3 new lots from the original holding as of January 18, 1979, subject to the additional consent criteria being met, as well as all other applicable policies in the official plan, and any other applicable policies in the County of Renfrew official plan and the provincial planning statement would continue to also be required to be met per the Planning Act. In terms of this public meeting, again, it's an opportunity for anyone to provide comments, either written or verbal, in support of or opposition to the proposed changes, again, and to preserve appeal rights. Persons need to ensure that they're providing comments prior to a decision being made. Again, just as a reminder, the decision is made by, although council passes a bylaw to adopt the official plan amendment, it is then required to be sent to the County of Renfrew, who is the Township of Laurentian Valley's approval authority for amendments to the official plan and for the official plan itself. That's the lower tier official plan for Laurentian Valley. Again, any comments or information provided as part of the public consultation process forms part of the public record, and by providing that, you're just giving us your consent to disclose that information and to share that as appropriate with the planning process. So in terms of the amendment, we didn't receive any opposition written notices to this. We did receive 1 or 2 inquiries related to some of the language, and as noted in my report to council, one of the adjustments that's in it is recognizing in situations where there are lands that have full municipal services and are part of a bigger development concept where retained lands will be in part of a condominium or subdivision or site plan application, that there might be the ability, subject to meeting all other requirements as set out, such as the full concept envisioning, that there might be the opportunity to advance the 6 lots without the first 3 having been constructed upon. The same policy is not being proposed in the rural area, keeping the rural policies consistent with what is in the county official plan and other official plans, where it's that generally the demonstration that the first 3 are built upon before the next 3 are started and subject to the consent criteria. The other item that is based on conversations with the county and in accordance with the current practice, it's amending the provision that relates to the minimum lot size without need for a letter of report from a hydrogeologist, which the current practice is that it's generally 2.5 acres, which is 1 hectare. The township official plan had referenced 1 acre. However, the practice has been that it's been required that it's 2.5 generally to have that information provided, or if you're going less. So that is the only other change that was noted.
Okay, questions to council. Brian?
That just seems like a huge increase, 2.5 times from 1 acre to 2.5 acres. And I know most of us here certainly don't have 2.5 acre lots, and it seems to be sufficient.
So the issue is in areas where, because there can be areas where soil conditions or there's already a density of other wells and septics on smaller lots, that there does come a point where it could be creating an issue. So it's not, the policy doesn't say that you can't have less than the 2.5, but if you're going less than the 2.5, you need to provide some supporting information from a hydrogeologist saying that it's large enough based on the soil and the unique conditions of that particular lot to support it. And it's a shall generally, so it does give a little bit of wiggle room, but that's been the practice for about the last 5 years, that all severances have been required to be that, or else they provide the letter report from the hydrogeologist, and we do get a bit of both. And it's just that also, without having any additional information provided, you're assuring that you have the ability to have an area for a backup septic bed should there be a failure, and also the spacing.
More protection for the municipality. Alan?
So you're telling me that that's been Laurentian Valley's practice over the last number of years? Because that's the first I've ever heard of it. And I know that in other municipalities that follow the County of Renfrew official plan, it's a real contentious issue about the size of the lots that they need to have in other municipalities that don't have their own official plan. So like I say, that's news to me, and like Brian said, I think that's a little much, over-doubling what they are today.
Yeah, so the guidance for that does come from the Ministry of the MECP, Ministry of Environment's Community Park. So it is a policy that is in the county official plan that was also brought in through provincial legislation as well for what the recommendations. No, but again, it's also looking to that other legislation. So in terms of if council wants to remove that, the caution may be that the county may still, when they approve, modify it to bring that in, because that has been the practice. And again, it's not to say that you can't have a lot that's smaller, but you need to demonstrate that that it's able to be supported based on the soil conditions in the area.
But I thought that's why we had our own official plan, so that we didn't have to follow the rules and regulations of the county. And if we're going to all of a sudden start adopting all of the policies of the Renfrew County official plan, then why do we bother having our own official plan?
So I'd say with this particular policy, again, it does loop back to some provincial policy as well. And again, if council wishes to direct that we strike that through in the amendment that's adopted by council put to the county, we can do so. Again, just in practice, that has been the requirement, and that's what has been addressed. But I can absolutely take that direction from council and put that in.
I would make that recommendation if somebody wants to support it.
My lot's an 1.5 acres, and the house and septic and well and everything is on half of that. So, like 2.5 is huge.
What if we bring it down to 1.5?
Why don't we just leave it where it was? We were.
Oh, Lord's saying it's been 2.5 for 5 years.
No, not in Laurentian Valley.
With County of Renfrew Land Division Committee, that has been the requirement. So anytime when there's been a submission within the township, if it's they're providing that information again in accordance with provincial guidance.
So where's Laurentian Valley today?
So the language in the official plan that we have says shall generally be 1 acre or else will require a hydrogeological review.
Okay. So what is council's wishes?
My recommendation to keep it the way it is today. The idea of this is people were wanting to be able to sever more than 3 lots off of an existing holding, or not lots, sever 3 parcels, some of them being bigger, some of them being smaller. Not all are going to be residential lots, small residential lots. Some of them are going to be bigger pieces of where people want to divide a farm in half that today they can't because they're already at that number. And if we're going to move this along but make it way more restrictive, then my question is, why do it then? We're just, I think, defeating our purpose if we're now saying you got to be a hectare lot I thought the idea before was we didn't want to have all kinds of infilling and everything all over the place, so we didn't want to be taking up agricultural land, and now we're saying all the lots have to be double the size, over double the size of what they are today.
Okay, Jennifer?
I second it.
Okay.
So what do you need from us, Lori, with regards to the motion? Do you want it in there, or are you just going to make the change in the bylaw based on the comments tonight?
I can do it that way, or if council wants to enshrine that, they could add, you could add just to the motion, and as amended to revise to 1 acre minimum, and that should be enough direction to alter the amendment packages that will have to be sent to the county.
Make sure you can read your own writing, Dean.
Yeah, okay, thanks. Okay.
Moved by Alan, second by Jennifer.
Moved by Councillor Wren, second by Councillor Gauthier, that council does hereby adopt official plan amendment file number 23, OPA number 23, being bylaw file number 2026-03 as presented in order to establish policies for additional consent criteria in the Township of Laurentian Valley official plan, and forwards bylaw, adopting bylaw of 2026-07-033 to the bylaw portion of special council meeting of July 29, 2026 for passage, and further directs the township planner to submit the required documentation to the County of Renfrew Approval Authority to support the request for approval, as well as amended to include the current size lots.
All in favor? Carried. Motion to adjourn the public meeting. Betty and Wendy.
Moved by Councillor King, second by Councillor Hewitt, that the special council meeting of Laurentian Valley Township hereby declare the public meeting of July 29, 2026 at 5:30 p.m.
All in favor? Carried.
So I
Thank
think
you.
we'll put a delegation.
Yes. Yeah, we're gonna go back up.
Delegation.
So we generally start our council meeting at 5:30, so we're right on time for the City of Pembroke's presentation.
Dave, you can pull a chair up if you want to be at the table, or if you're comfortable there, or whatever.
I like your back.
Yeah.
Welcome, Angela and Jennifer.
Thank you.
Okay, so thank you, and good afternoon, good evening. For those of you who don't know me, my name is Angela Lochte, and I'm the Director of Corporate Services, Treasurer, Deputy Clerk for the City of Pembroke. With me tonight is Jennifer Belair, who's our Financial Planning Analyst and is responsible for the asset management plan of the city and putting that together. And in the gallery tonight, we have Dave Unruh, our CIO, and Mayor Ron Gervais. Here tonight, we're here to present some information that we presented to council back in June. As you're aware, our two communities, being the City of Pembroke and the Township of Laurentian Valley, have a shared recreation agreement where we share the cost of the operation of Pembroke's 3 recreation facilities, being the PMC, the PACC or PEMICE 2, as well as the pool. So over the past several years, our council has joined forces to discuss the future of these aging facilities and the next steps. So to assist with this analysis and as part of the city's asset management plan, Treasury staff, along with the City Recreation Department, have worked with the firm Aegis to provide an updated building condition assessment. So these BCAs have been reviewed in detail by both the Recreation Department as well as Jennifer, who, as I mentioned, coordinates the city's asset management plan and has summarized all of this information into the presentation tonight. for my role, I have reviewed the implications of this information, both in terms of any debt that might be required to finance the plan, as well as the long-term financial planning impacts of these shared recreation facilities over the next 10 years. So that's what we'll be reviewing with you tonight. So it should be noted that unless stated otherwise, the figures presented are the full financial requirements of the three facilities and does not include any type of breakdown other than talking about what kind of funding gap we have right now of who pays for what between the two municipalities. So we're here to simply present an overview of what these buildings require. And with this information, we hope to inform the future strategy of recreation in our two communities over the next term of council. So as I mentioned, in 2025, Aegis completed building condition assessments of the city's three recreation facilities, and they performed their actual on-site analysis of the three buildings in the fall of 2025. So this includes the Kinsman Pool, the Pembroke Area Community Center, as well as the Pembroke Memorial Center. So as part of the overall assessment of these buildings, they calculate what's called a Facility Condition Index, which essentially looks at all of the different components of the building that require renewal in the first 2 years, divided by what they consider to be the building's value. So based on Aegis's assessment, the pool and the PACC are rated in poor condition, with the PMC in fair condition. And they've calculated building values based on industry standards. So this is not necessarily comparable to future facility replacement costs, which we'll go over in the next couple slides. And we do anticipate that any replacement costs would be higher, as these buildings would not be replaced on a like-for-like basis, and that any new buildings would be designed for current and future user expectations, codes, and regulations. So with the Kinsman Pool, it was built in 1956. It's 70 years old, and it's considered to have for the building is considered to have a replacement cost of $5.2 million. So given the amount of work the building requires over the next couple of years versus this value, it's considered in poor condition. The PEMICE 2 was built in 1977. It's almost 50 years old. It has a replacement value of $10.2 million. Again, it's considered to be in poor condition because of the work that's required. The Pembroke Memorial Center was built in 1951. It's 75 years old. It's considered to have a replacement cost of $18.2 million, and is considered to be in fair condition.
Angela, sorry, just to interrupt for a second.
Yeah.
Would you prefer we save our questions to the end, or just at the end of each slide or whatever?
So maybe let me go 2 slides ahead, and then I'll pause for questions, because I know when we presented that first slide, we had a ton of questions from council.
Okay.
So I've added a few slides in, because right away, one of the first questions we had was, well, wait a minute, because when we're looking at replacing the pool, it's for a lot more than $5 million.
Right, okay.
So certainly, Aegis uses their own cost guides in terms of how they assess what they consider the replacement cost to be. So in this case, they assess the replacement cost as being $450 a square foot, and in the $300 a square foot for the arenas. Certainly, there's a range of values that could be used for the replacement cost of these buildings. So we did take a look at this using the Altus Group Canadian Cost Guide for Ottawa as a comparison. And for example, the Aquatic Center in this guide has a range of costs per square foot of a building of 11,700 square feet. And they're saying the low end is $570 a square foot, the high end is $780. So if we look at those values, that puts the building value in between $6 and $9 million. So that could actually push the building into a fair condition, which, we would hope to see, seeing as how we just replaced the roof structure of the building. The 2 arenas, again, the PACC is still in poor condition. We do have a pretty large upgrade on the books for next year for this arena in terms of replacing the floor, the ice floor system, as well as the rink boards. Again, the range of replacement for that building could be anywhere between 11 and 15 million, and the PMC, obviously a much larger building, could be anywhere between $20,000 and $27,000, and that could be anywhere between fair and good condition, depending on what that bottom line building value is. So certainly there's a bit of, I guess, professional judgment involved. You just used fairly low values. Obviously, if we look at the high end, based on the Altus Group guide, that actually does change the FCI for 2 of the buildings. Obviously, both councils have talked about replacing the pool in the past. The pool replacement that we looked at back in 2023 included a much larger facility. So in addition to replacing the existing pool, we also considered adding a second therapeutic pool to it, as well as other community spaces in the building, which would increase the overall square footage of the building from the 11,700 that it is now to a 36,000 square foot building. At that time, the consultant that we had that put that cost together estimated a cost per square foot of $777, so the high end of the Altus Group's units that they use, which would put the building value at 28 million. Added to that, they estimated about 5.6 to develop the site, so basically we'd be starting from scratch. Another 3 million for design, another 8 million for contingencies, and if we wanted to make the building net zero, which could meet some grant criteria, this puts the building estimate at about 50 million. So obviously there's a big difference between just looking at the older building in a small size, with undersized change rooms that doesn't necessarily meet the needs of today's community that was built in the 1950s, to a modern facility that we'd be looking at, should this be a path we would want to do in the future. So I'll pause here and see if there's any questions.
Okay, maybe I'll start off. I guess my concern is, and this goes back to our joint rec group that we've been meeting over the last year, is the word poor. You've explained the word poor meaning the building is in poor condition. That's it? Is that the only explanation they give to you, that poor means the building is in poor condition, or the facility is? Because it needs so much more money, it needs so much money to bring it up to a fair or good standard? Poor is a very tough word to use. I'm sure you've heard this before, but it concerns me. And my second question is, once the upgrade to the ice floor and rink board is done at PEMICE 2, do you know if they would move it from poor to fair? Or has that question been asked?
Okay, so we would have to calculate that in terms of what they would consider the cost to be. But essentially, it's looking at, I guess, these buildings are old, and what the BCA looks at is replacing components of the building that are at end of life. So what it's saying is a large proportion of the building has components in it that are end of life. And because of the dollar value of those end of life replacements that are required, the building is considered to be in poor condition. Now, when you walk in the door of the PACC, it looks great, right? It's fresh paint, looks good. It's the guts of the building that the assessment's looking at, and not necessarily the fit up of the interior. So that's just the proportion of the work that's involved that puts it into the poor. So, but certainly I would imagine that the upgrades of the PACC, which are over $1 million, would likely at least move it into fair. But again, we also have siding and roofing and different items that are also going to come into play with that.
Okay, thank you. Anybody else? No, go ahead.
So I'm going to pass the microphone over to Jennifer. So she spent quite a bit of time with the Recreation Department going over all of the information in the BCA and pulling it together into a summary. So pass it over to you.
So the renewal costs that are showing in the BCA reports, so we didn't account for inflation at this point. So they identified the need for over 20 million in building component repairs, maintenance, and replacement over the next 20 years. And we did want to mention, so until a decision is made to replace a building, our long-term financial planning will assume ongoing renewal to maintain service to residents for the 3 facilities. So this is a breakdown from the report before we made any adjustments. So it shows the total over the 20 years for each facility. So the review process, we started with Aegis completing the building condition assessments, and they look at any documents or reports that we have available. They do a site inspection, they do a condition assessment, and they look at long-term capital forecasting. So the experienced professionals assessed major building systems, identified deficiencies, they estimate remaining useful life. They document the observed age of components, so not just the estimated useful life, and it's based on the current condition. And they recommend repair or replacement timing. Their technical expertise and professional judgment help ensure the BCA provides a reliable basis for capital planning, budgeting, and asset management. And the reported figures reflect required corrective action and end-of-life replacements. So reviewing this with multiple city staff, we looked at the recommendations and we made a few adjustments. So we separated some operating activities from capital so that we have a better understanding of where we need to provide funding. We removed any upgrades that aren't required under current building codes. We updated forecast costs. So if they undervalued something that we've been made aware of through tenders from other municipalities, then we updated those costs. We also adjusted for inflation. And we included 2 building improvement projects. So the expansion of PACC for additional change rooms, as well as addressing the parking lot drainage and paving. And then as well as an expansion to the Kinsman pool for additional change rooms, and potentially changing the wading pool to a splash pad. So this is looking at the 10-year repairs and maintenance. So this is where we pulled the operating activities away from the capital, and we did address or adjust for inflation. So this tells us that between the 3 buildings, we're expecting repairs and maintenance of about $200,000 per year. And these haven't been historically funded, so we will need to consider these in upcoming operating budgets.
I'm sorry, what do you mean by historically funded?
So in the operating budget, they've typically been doing more reactive maintenance. So this is where there's operating activities addressed in the BCA that are telling us that certain activities need to be done in certain years. So this is separating the capital out. So it's showing about 20 million over the next 10 years, so an average of 2 million per year in capital projects. So understanding that the capital needs are higher than our current funding, we have identified a few projects that likely will be assumed under debt financing. So that's the PACC floor and siding, the PMC floor, elevator, and parking lot, the PACC addition and parking lot, as well as that addition to the Kinsman pool.
So the floor is being done this year, or I thought it was next year?
It is.
It was identified in our 2026 budget. So if it's still ongoing next year, it'll be carried forward.
So the plan is to do the design in 26 and the actual replacement in 27. But it was included, from the city's point of view, it was included in the 2026 budget.
Oh, in your budget, okay, okay. Thank you.
So we've removed those debt projects to show a capital projects funded by taxation. So it's about 900,000 on average per year for the next 10 years. So after we presented to our council, a further breakdown of capital projects was requested. So we provided a summary based on the uniformat code that's used. So this slide is for the pool, at a level 1, so substructure, shell, interiors, etc. And the next slide breaks it down to level 2 or 3, just to get a little bit better idea of the types of work that's been identified. So there's a set of those for each facility.
Sorry, can I just go back, Angela, just a quick question, or Jennifer, I guess, to slide 10, and just go into debt financing requirements. Just trying to figure out exactly, just take the PACC, since we're doing that, that's been a request, 2.275 million, estimated debt repayment is 157, that's based on a 25-year loan? Eh?
Yes.
Is that what you're planning to do that over? Yeah.
Right, so this isn't looking at who pays for what, this
No,
is just,
the
if we
cost.
had to take on a loan for 2.2 million over 25 years with the, I believe that's a couple months old now, that loan
Yeah,
rate
whatever,
for
yeah, I'm just
25
getting
years.
it, yeah, but-
It would increase the taxation budget by $157,000 a year.
But you would, the recommendation would be to finance that over 25 years?
So that's a standard, I mean,
I just asked, at this point,
just for
that's what you're
analysis.
thinking. All right.
Like, I'm thinking that's the that's the largest term we would likely give a
Yeah.
project like that, because it should last about that long. I wouldn't see us going to a 30 with that, at least from the city's point of view, if we were to take on debt like that, but obviously that's something, like, this is just for discussion purposes, to give an idea of what the tax impacts
guess-
are.
I guess I look at that and just the reason, because of our discussion with the other facility, the new facility, if it ever was to materialize, is probably 10, 15 years out. And then you're probably gonna have some, that'll obviously do the floor in the arena. That'll be okay for 25 years, I would imagine, but then you're gonna have to be dealing with the building by 25, obviously, in 25. Yeah. Okay, I just wanted to know that, thank you.
Yeah, so just for clarification, just looking at the list of what's left, that's already a lot more than what we're spending right now. So what we tried to do as a financing strategy for our long-term financial plan was to try to group together some of those bigger ticket items and lump it together into something that we could do as, one big project and then get a loan for it to help try to finance all of the different needs of these buildings. But obviously that's, like, again, as I mentioned, this is for discussion, just to give us an idea of where we're at and how far behind we are and, what the goal is to try to work towards over the next few years.
Thank you.
So I'll skip over the details. So as I mentioned, as Jen mentioned, we did provide this additional information just to try to give a better breakdown. I mean, we didn't necessarily want to go into the weeds of all the little things that each building needed, but it does give you a better idea of sort of what the priorities are over the next 10 years. So when we look at all of these different requirements and we compare that to what are we actually spending right now? So from the city's budget, on average, because we do, spend a little more, a little less every year, but looking at the last 3 years, we spend about $284,000 on building projects for the 3 facilities. If we consider that the Laurentian Valley gives us a maximum contribution of $59,000, and we look at all of the different spending that's needed in the buildings over the next 10 years, it works out to be a funding gap of over $500,000 a year. Again, if we look at our operating funding, if we were to take on more debt, again, to help finance these projects, that's also going to put pressure on our operating costs. And if we take that along with all of the maintenance that's required for the buildings, again, that also puts pressure on the operating costs of the 3 facilities. So in 2026, we had a budget allocation of 1.6 million, and we're comparing that to an average 10-year operating requirement of 2.5 million. So overall, that's giving us an annual funding gap of almost $1 million. So this isn't all doom and gloom. So obviously, as part of this report, we're only looking at funding these issues through taxation and debt. But I mean, we do have other tools in our toolboxes. And we really need to, over the next term of council, decide exactly what we want to do, when we want to do it, and be shovel-ready so that we can seek out grant funding opportunities as they become available. Because certainly we applied to a grant for the PACC, and we submitted it, I believe, last week, and we already have a question back from the project. Is your project shovel-ready? Do you have designs ready? Are you ready to go? And the answer we have is, it'll be done by the end of this year, but we don't have it right this second. So we'll see how we score with that. But the more shovel-ready we can be, the better we can leverage some of that other funding that's out there. Obviously, we can't magically come up with another $1 million overnight. So we're going to have to look at phasing taxation increases over time, because I'm sure your municipality is no different than mine. We're all under, all of our residents have a certain affordability crisis that we're all going through in terms of the cost of living, the cost of housing versus available income. I know at the City of Pembroke, our historical past practice has always been trying to keep all of the budgets the same every year. And we really need to make sure we kind of move to a place where we're at least keeping pace with inflation versus always trying to maintain the previous year's budget. We're going to, as we do every year when we go over the budgets, is defer low-risk projects that don't impact service delivery where possible. So that there are certain things that we can't defer, but if we're going to have, we might need to have older washroom facilities, older change room facilities, if it's something that we can't afford to improve. But certainly if we want to have a rink, we need to maintain the ability to have ice on that rink. So certainly looking at deferring low-risk projects where we can. We may need to consider additional debt over and above the 4 projects that we identified to address the backlog. So that's something, we'll have to have more discussions between the 2 parties together. Obviously, now knowing the gap and knowing the importance of these facilities are to the community, we've certainly seen a pretty significant backlash with with being able to maintain these facilities and being able to continue to offer the pool, for example, to our community. We should look at our recreation agreement together. As we look ahead, certainly what we've both contributed in the past doesn't reflect what's needed in the future. And, we've certainly seen a lot of support in our local community. The pool fundraising group did an amazing job raising significant funds to help keep our pool open. So certainly looking at that, looking at building naming rights, looking at our user fees are all things that we can look at to try to help manage the gap between how much we're spending now and how much we need to spend in the future to be able to maintain these services in the community. So as a wrap up, I have sort of looked at the operating costs over the next 10 years and just provided a forecast for council and staff's information to look at it on your side. Assuming that we increase user fees by 5% every year, we expect about a 3.25% labor cost increase every year, at least based on the current collective agreement that we have at the city, as well as a 3% increase in operating costs year over year. And we have, for discussion, put in a possible phasing where we slowly increase the budget year over year, both on the operating side and on the capital side, to try to build in extra funding to help pay for the work that's required, and hopefully try to defer wherever we can to try to match the funding that's available. So certainly, looking at the requirements, it does look like we're going to need to increase our budget year over year to provide the necessary funding to maintain the facilities. Given that in the past, the funding that we've received from Laurentian Valley has fluctuated year by year, it might be beneficial to have steady contributions where if we don't require it in a particular year, we put it into a joint reserve, and then the next year, when all of a sudden we need to spend a little more money, we can pull from that, might be the way to go, similar to what we do with our water sewer agreement. So that would require further conversation between the parties. And I guess in terms of the pool, we do need to do basin upgrades in 2031 according to the building condition assessment. So if this is a cost we want to avoid, then we should decide whether or not we want to construct a new pool in early 2029 to avoid these additional costs. So again, all of this information tonight is presented for discussion purposes and, is subject to further review between, city staff, city council, Laurentian Valley staff, Laurentian Valley Council. But we did want to give you an update just because of the significant dollar amounts that are involved. So again, we'll pass it back for questions.
Thanks very much, Angela. It's very informative. It is kind of a doom and gloom in a way, for sure. There's a lot of gaps there. Anyways, the council will take it under review and we'll await meetings down the road. Alan?
So there's been all kinds of talk about a new pool, new rinks down the road, and now we're talking about 2035, we're going to start borrowing money out. When are we going to decide where it is we're going with this? We don't want to be in 2030 and have 5 more years of debt in a building that's going to be retired because we built a new facility. Or do we need a pool that needs to be double the size of what it is today? Can we actually afford it? When we start throwing numbers out like $50 million, that's $2,000 per person. We're going to be putting people out of their houses if we do that. Even 20 million, it's another $800 per person. We're throwing these numbers out there like, there's all kinds of money, we're flush with it. The other thing I have is where's Billy and Cheryl, okay? They need to be at these meetings, okay? We need to start holding them accountable and making sure that there's funding coming to these areas. I don't think we're doing enough of that at this point. There's money going to recreation facilities all over the province of Ontario. It's happening, okay? This area is getting absolutely nothing. I drove past one in the middle of nowhere up by Bancroft. It's 2 ice surfaces that just went in. It's a beautiful, big Ontario sign saying that it's not Northern Ontario, right? And they're getting money. So we really need to start pushing on both of those people, and we need to start pushing on them hard to make sure that they're doing their job for this area. But it's very scary for people that, like you say right now, are financially challenged, and to listen to this, it scared the hell out of me.
Certainly getting projects shovel-ready is huge, as you said earlier tonight. And I think that will be, or should be, a huge focus, going down the road. And the committee is working on possibilities, and with the water and sewer increases coming up, it's, as Alan said, it's doom and gloom as far as trying to save money, let alone pay the bills to keep these buildings going. So it's going to be a tough go for the next little while, but thanks very much for the information. David.
Yeah.
Okay, so I just wanted to say thank you. So I think this is Leslie can correct me, probably the first time the City of Pembroke has come and presented to your council. So I appreciate the opportunity to, talk to you directly. And, I've been really pleased and excited about the opportunities of the 2 communities working together. Yes, it is, some heavy lifting that has to be done, but I think together that we can do it and we can come up with some solutions. So I just wanted to say thank you, from City of Pembroke to allow us to come and deliver this message. Not a great message, but deliver the message in person. Thanks.
Okay, thank you. And thank you, Ron, as well. And sorry to keep you waiting that hour. I didn't expect it to be that long.
If you want to sit down and join us for the rest of the meeting, Angela, you can.
We'll go eat the snacks.
Yeah, okay.
Okay, so we're down to business. Jackson Holdings, Lori?
Yes, so the other item we now also have before council is an authorization for the mayor and CAO to enter into a development agreement related to the improvements and extension of Dix Road. It's one of the conditions for removal of the holding symbol related to the Traxton Holding Limited's French Hill Quarry. So this was the official plan amendment, zoning bylaw amendment that was previously approved by council a couple of years ago, and then they've been working through all of their other requirements and have been in consultation with our public works manager as well. So we've come to a point where there's basically a plan for the works, and this would be authorizing the agreement. Now, since the publishing of the report, one of the other comments we have had back from Traxton just would be an adjustment in terms of the dates that would be instead of specifying the actual date within the agreement, we would have it based on the certain number of years from the issuance of the aggregate licenses. That still there's a kind of chicken and egg process to come. So assuming that we have all the conditions for removal of the holding symbol met, then the next step would be that we would deal with the bylaw, like I would, as a delegated authority bylaw, deal with the bylaw removing that holding symbol, and then the province would issue the license. So this is, again, one of those key pieces that is within the requirements that the township had. Again, there was a report, traffic impact report prepared by Novatech, and then again, more detailed information and a number of site meetings with the public works manager. And then we also had received, the public works manager is in review, the proposal with the cost of the work, so that we'll just ensure that that is the appropriate amount before signing off for the securities related to the agreement.
Okay, any questions of council? Motion? Brian and Wendy?
Moved by Councillor Ugly, second by Councillor Hewitt, that the council for bylaw 2026-07034 as presented to the bylaw portion of the special council meeting of July 29, 2026 for passing in order to authorize the mayor and the CAO to enter into agreement with Traxton Holdings Limited to extend Dix Road and undertake certain road improvements to satisfy a condition for the removal of the holding symbol for the French Hill Quarry.
All in favor? Carried. Okay, Laurie, move on to development charges.
Yes, so this was just bringing back the revised roads and related draft capital program. So the presentation that was made by Watson did have a certain potential development charge maximum. And then in terms of the discussion with council, it was that there may be items to potentially review, again, with the draft capital program, as there were a number of items that have been brought over from the joint transportation master plan east-west traffic that was done with the city of Pembroke. We did note in doing this review that there was, we do believe, at least one or two items that we had actually previously deleted from the list that somehow had remained through, but just to bring this back through for council to see what we would be putting back to them to do a next final draft. Again, just as a reminder as well of how this process would work is when they refine the numbers and they bring it back, we would then take that draft report. It has to be out for quite a long number of days prior to the public meeting. It's a little bit different than some of the other processes, so it needs to be available for 60 days prior to the public meeting. So this would give an opportunity to get that finalized. It still does leave council with a further opportunity that even though that would provide a recommendation for the maximum eligible development charge that could be collected, that council could still choose when moving towards that next stage to adopt the bylaw to provide further reductions from the maximum that's allowable. So, but this will give the adjustment of the calculation. Again, as you can see, what we've attached to the report, there's the strike through of the items that would be being left. Again, some of them were outside of our jurisdiction, and some of them would be, more to the developer or a future review. And again, this was reviewed with the Public Works Manager, so Mark is also available here if there are questions about any of the deletions, or again, just also some of the changes adjusting to some of the adjusted realities from the last 6 months.
Okay, questions of council? Al?
Do we have like a guesstimate of how much this is going to change by taking out what we took out? Or you got to wait till they run all the numbers?
Yes, we would have to provide this back to them to run the numbers, because we don't have that ability to do the sensitivity ourselves, because we don't have those formulas here.
That's fine.
Okay, mover and seconder? Patty and Jennifer?
Moved by Councillor King, second by Councillor Gauthier, that council directs the township planner to provide Watson Associates, the consultant for the township development charges study, with an updated public works related capital items list per the additional review by the township public works manager for the draft study to be prepared for the public consultation process.
All in favor? Carried. Okay, administrative monetary penalties, Brett, please.
Okay, thank you.
Sorry to put you on the spot earlier, but...
No, that's all part of it. So, unfortunately, my job's not always good answers, but or answers people want. But yeah. So I also do have Shane on, who we've hired to help with the AMPS program and rewriting some of our bylaws. So if there are questions, we can promote him and get him to speak as well.
Maybe, Brett, can you just take a preamble of what we're doing here, just for council?
Yeah. So the report's longer than you used to from me, because that was to give you a recap and some background. But essentially, we've noted that our bylaws are dated and our enforcement tools are lacking, I guess is a way to say it. So in last year's budget, we set aside some money to look into and start new systems where we can actually have more enforcement tools, set fines we don't have to go to court to have approved, which obviously makes it easier to want to move forward with, makes more sense. The route a lot of the province has been going is with this AMPS, Administrative Monetary Penalty System. Lots of pros which were identified, very few cons. There's background help to try and collect and stuff like that as well too. So it is, I think, the way of the future. I mean, there could be other options out there or more to come, but it's certainly the one that we lean towards, or I lean towards in my recommendations. As such, we're here basically now to adopt and start the actual AMPS bylaw, so that we can move our other bylaws to that system. So you can see kind of the rundown on what it is. We don't have to start with a ticket either. Like, we can still do what we've done now with a notice of infraction, but basically we have the option. Set fines are set out in advance and pre-approved, basically. So we can issue a ticket. If they want to dispute it, they go to a screening officer, which is more informal. It's not through court. It could be subcontracted, or it could be a municipal employee. They basically make a decision. They can confirm the ticket's valid and it stands as is. They can reduce the amount of the fine if they choose, or cancel it completely. But their decision's not final either. So if they still don't like that decision, they can then appeal it to a hearing officer. That person can't be a municipal employee. It would have to be someone that we've appointed or hired. And then they basically can do the same thing. So confirm, reduce, or throw out. But their decision is final. So, like I say, by subcontracting out, there are some companies that will do it on a per use basis. So there's no annual fees. There's no upfront costs. You just, if somebody appeals the ticket, we pay them. And again, there are surcharges and stuff that we can add to actually recoup that back too. So financially, it really makes sense rather than, like right now, we would have to actually go through the court process to do a fine. And the amount of stuff that we can cover through AMPS, like it can take care of essentially all of our property standards. We're going to do a clean yards bylaw. We can do parking, winter parking. I believe fire is even under there. And it's still in discussion phases, but there have been talks about moving some of the planning bylaws to AMPS as well too. So if that gets approved, like we could do everything under one system, and I think it would really help us modernize and reduce the number of infractions. I think once the word gets out that there are consequences again, like it shouldn't take long. We haven't put it in the initial draft, but there is also an option. You can have increased amounts for repeat offenders, which is, maybe something to look at. We'll see. We can adjust this basically at any time just with amendments to schedules. So it's a nice, clean, easy way to add things to it. Tonight we were going to start with just the winter parking bylaw. We want to make sure that we have that ready as early as we can. So we're targeting December 1st for that to be in effect. We can start advertising it before that, obviously, if council approves everything and we get some verbiage to set that out. So I know in speaking with the guys plowing, they're looking forward to something other than the letter on the window. And obviously, personally speaking, the amount of property standards issues that we've had, it would be nice to have something that we can actually move forward with efficiently. So
yeah, for sure. Long overdue. Betty.
That was going to be my comment too. It's about time we start putting some teeth in some of our bylaws. I think it would also help alleviate something similar to what we witnessed earlier this evening, where it's, oops, I forgot, I'll get it done later. It's something that will hold, like you say, hold people accountable. I agree with starting with the winter plowing or the winter snow removal bylaw. One thing I would suggest that I noticed when I read through is I know City of Pembroke has at all entrances of coming into the city, there's a sign posted, winter hours, that no on-street parking from 1st of November to whatever, bylaws and fines. So I think that, along with public announcements, is very good. But no, totally, it's long past overdue that we start looking at putting some teeth into some of our bylaws.
Al.
Couple things. So any of the income from any of those infractions go directly to the municipality then? It doesn't go through provincial offenses? Or
no,
like that.
that's another...
That's a good thing.
Yeah.
Okay. Yeah. The other thing is, so for the on-street parking, can it go back through MTO on the license plate then, if they don't pay it?
Yes.
It can.
Yeah, and that's part of why we're wanting to start it early. We have to enter an agreement with the MTO. ARES, I believe, is the acronym for it. But there will be some stuff to set up. But Shane will look after all of that.
Now, we don't renew license plates, so would it be driver's license? I know from a previous job, I used to be bylaw for City of Pembroke, and we used to be able to go to the license plates. Now, since people don't renew their plate, would it go to their driver's license then?
No.
So it still goes against their plate?
Yeah.
So if you have an outstanding ticket, okay, and your plate won't automatically renew. So you have to pay that ticket before you can get it to automatically renew. So it will come up in the police car that the plate hasn't been renewed.
Correct, yeah. And there are surcharges and stuff as well too. So like, strictly financially, it makes real good sense for us to do this. And the number of bylaws we can deal with, like winter parking is the first, obviously, because there's more to set up. Before spring, we're going to have the clean yards bylaw. We don't have a clean yards bylaw right now. We use our property standards, which is, it works, but it's more long-term. It takes longer to get things done. So that will be the next one. And then, we'll see what the more common contraventions are. And at the guidance of council, we can add almost anything.
Wendy?
I think this is a wonderful idea as well. So I'm just after reading through the report, it sounds like we need to actually appoint a screening officer. Is that my understanding?
Before this is live, yes.
Yeah.
We'll have to decide what we're doing, whether we hire and appoint or whether we do someone internally. I don't know how often it would be used. So, the hearing officer has to be external. So I would suggest that we subcontract that out. Depending what the volume is or what direction is, we can do some tenders. Shane's company does that because it's all virtual or can be virtual. I didn't get a written estimate, but what he mentioned for a screening was quite cheap. I think it would be wise to do that. Maybe for the first year, we could appoint someone internally if council thinks that's wise for the screening portion, and just see how often it's used and how much workload it does add. If it's only 2 screenings a year, we may be able to continue that, but I think, and it will be up to the public to give us feedback, but I think if anyone gets a ticket, it's going to be pretty cut and dry. We're not out there looking for stuff, so if we're reacting to a complaint, it's usually valid and well-documented photographs. I don't think there might be people that aren't happy with it, but I don't think there should be many appeal it. But we'll see once it's active.
So are you the person that's going to actually lay the charge, or who's?
So we can set it up basically so that it's anyone appointed as municipal bylaw officer. So we can use MLES still. There were talks, Brad Fott had volunteered to be appointed, should council direct him to do so, to deal with just the winter parking.
Okay.
Because he is the one that does a lot of the patrols and is more available for those issues. But yeah, we can amend officers and have people do different things.
You think right away, parking in front of Walmart, parking in front of Canadian Tire. Is that different?
Yes, okay. And we had that. I had a call on that actually today about parking in the handicap spots. So unfortunately, it's still private property. So if they don't request us to enforce it, we can't.
Right.
It's basically just our bylaws, our streets, our property. Now, I don't know. In the past, there hasn't been any appetite from them. They've always said that they would self-police their parking,
Yes.
but...
And I don't think any corporate store today want to start the...
No, it's a tricky...
process. It can be pretty tricky too. So.
It's a tricky line for them.
Okay, Wendy.
Just to follow up with that, I personally would like to suggest that we have someone, a municipal staff person at least to start, to see how it goes. That would be my suggestion.
Yeah. And I mean, as part of the contract we got through Shane to develop this system, he did offer training and stuff as well too. So we can certainly do that and amend things and just see, see how it goes the first year and bring it back as volume increases, or if it's working, it's working.
No, it's great. Number one, get a motion. Alan and Keith.
Moved by Councillor Wren, second by Councillor Reeve Watt, that the council enact the administrative monetary penalties bylaw for the bylaw infractions as outlined in this report, and council enact bylaw to amend parking bylaw 0202124 to provide for the issuance of penalty notices pursuant to administrative monetary penalty bylaw, and further that bylaws numbers 2027 07 035 and 27 07 036 be forwarded to the bylaws section of the July 29, 2026 special meeting for enactment. 26? Pardon? There's supposed to be 26 bylaws? Right now we have them as 27 in this motion. I'm just making sure. Sorry? 27? Okay. Okay. No, but 2027-07. No, it's 26, okay. Sorry, I'm correcting, 26.
All in favor?
Good.
We know the year.
Yeah, I'm not sure why they're 27.
Okay, animal control. Thanks, Brett.
Hey? We got 357 first, yeah, okay.
Property tax, sorry, Annie.
Jumped her.
All right, so this is a report that requires council's authorization for us to process the cancellation or reduction of property taxes on certain properties, as we receive some tax applications for Section 357 of the Municipal Act. So for a total of $15,298.66. So this is, like I said, according to the Municipal Act, where council can decide to cancel, reduce, or refund all parts of taxes that were levied, depending on certain conditions. So we did receive final applications that were fully completed for 6 different ones for Section 357. And so 4 of them were for reasons of fires. They were destroyed by fire. And then we had 2 that were change of classification, so maybe going from commercial to residential. And so those make up the 6 for the 15,000, and then they're broken down, of course, between the portion that is Laurentian Valley, the County of Renfrew, and the school boards, and you have the amounts here in the report. So we might have a few more come later so we can bring them back, but they were not completed yet. But for now, we have these, and yeah, any questions?
No, and I believe, yeah, no, I'm good. Okay, move to seconder. Wendy and Brian?
Moved by Councillor Hewitt, second by Councillor Ugly, that the council authorize the treasurer through Section 357, 358 of the Municipal Act 2001 process the cancellation, reduction, and refunds of property tax for certain properties in the amount of $15,298.66.
All in favor? Carried. Okay, who's doing animal control?
Lori is.
Hello, good evening. As you know, we contract the animal control and bylaw enforcement with MLES, and that contract has now expired, and we have also used the two renewal terms that were in the contract. So we did go out to RFP, and we received 1 submission, and that was from Municipal Law Enforcement Services, MLES. And including in the package was a draft, or their submission, as well as a draft contract. So before you, we have a request for approving the bid submission from MLES. and that we enact the contract for them, so for 4 years, commencing August 1st. Any questions?
Question, Alan and Brian?
Just wondering what the difference is from the last contract, price-wise.
Yeah, $3 an hour
Difference,
addition, yeah.
that's good.
Same question? You want to make a motion? No, you just did. I'm going to do somebody else. Okay, first and second, Betty and Jennifer.
I wrote Brian. Betty.
Took it away from him.
Moved by Councillor King, second by Councillor Gauthier, that the Council of Township of Laurentian Valley approve the bid submission from MLES Services for Animal Control Services, Bylaw Enforcement Services for the period of 4 years commencing August 1st, 2026, and that the Bylaw 2026-07037 to authorize the mayor and the clerk to enter into a service contract with MLES for Animal Control Services and the Bylaw Enforcement Services for the Township of Laurentian Valley, as presented and be forwarded to the bylaw portion of the special council meeting of July 29, 2026 for enactment.
All in favor? Carried.
Maybe just to add, for council's purpose, we did also tender the housing, I guess, animal shelter kind of, and we did, it closed, but there was some questions. We are meeting with we did only, unfortunately, fortunately or unfortunately, whatever we want to get one there too, but we're just doing some questions there, so that will be coming to the September meeting.
Thanks, Laurie. Animal report? Any questions? Okay. Laurentian Valley Community Grant Report, Mr. Neff.
Good evening, Council. Before you have my report on our first intake of the LV Community Grant, I think it went pretty well. We had 11 applicants apply. We learned a little bit, as you can see in the report, from the process, so we're going to refine that, with the goal being that when we do submit these, we also submit our findings and the applications and everything, so a little bit of work in progress, but we definitely learned a lot. And then in that process, we've basically, the committee is recommending awarding $3,400 to support the following community organizations: Crossroads Community Club for $1,500, the OV Busker Fest, First Step Options for $500, and Pembroke Little League for $400. And I just essentially need a motion if council agrees with that, or there's any questions or anything like that.
Questions at all on what was done? Wendy?
I'm just curious, these amounts, were they the amounts that they asked for, or that's?
So quite a few of them asked for more than, because we set it at 5,000. We definitely saw there was more that were requesting for up to that amount, but the committee kind of tried to spread the money around. There was a lot of good applications. The goal, I think, with this is eventually that when we have the applications included in the scoring and everything, that we can start to kind of get a little bit of a track record of how we're grading this and how we're essentially valuing these. But for right now, yeah, we pretty much went with to try to spread the money around. So I think the only one maybe was Pembroke Little League. That was what they actually asked for, but the rest we scaled it down a little bit just to spread the money around a little bit better.
I do like this process that we're doing.
Yeah, and it was good to sit on that committee. Again, it's a learning curve for Chris and Nevada and myself, and Jennifer that sat on the committee, and you kind of get a better picture of what the organization, how it's operating, how much money does it have, what do you need the money for. The bottom line is you try and give as much as you can. Keep in mind that there are other, now in this case, we didn't even give out all the money we had, because there was a couple that we sent back for clarification that we could take some of the money from the first half to the second half and possibly spend it there.
Yes, absolutely. And there were some that we were already kind of funding through our previous budget, so we just tried to keep it fair. But like the mayor was saying, the process is a lot more transparent. It was a lot more, we felt like we learned a lot from diving into the budgets and trying to understand their organization. And so the goal as we kind of grow with this process, will be that council will essentially have our rubric, all the applications, everything in one, and then it will also be available to the public so that we can justify why we're spending that money, so it's fully transparent. And that we kind of also, along the way, are developing our own values about why we're giving money to certain organizations, which I think is going to be a key tool moving forward for the future grant applications.
Okay, who had a question, Brian?
I was just saying the only one that I had any question about was the Busker Fest being such a high percentage, you know, whether there was the need there compared to some of the other ones, but if you've got a rubrics that you're working on.
Yep. And we certainly didn't give as much as they asked for either.
Yeah.
Okay. Mover and seconder. Alan and Jennifer.
Moved by Councilor Wren, second by Councilor Gauthier, that Council of the Township of Laurentian Valley approves the recommendation of the LV Community Grant Committee for a total of $3,400 in support of the following community organizations: Crossroad Community Club $1,500, OV Busker Fest $1,000, First Step Options $500, and Pembroke Little League $400.
All in favor? Carried.
Thank you.
Thank you, Chris. Bylaws.
Mover, seconder.
Jennifer, Alan?
Moved by Councilor Gauthier, second by Councilor Wren, that the following bylaws be enacted and passed. The first be read a first, second, and third time, be numbered and signed by the mayor and the clerk and sealed with the seal of corporation, and be engrossed in the bylaw book this 29th day of July 2026. Bylaw 2026-07-031, zoning bylaw amendment Z 2026-10 Lubitz. Bylaw 2026-07-033, official plan amendment bylaw 2026-03, OPA number 23, additional consent criteria. Bylaw 2026-07-034, to authorize the mayor and the CAO to enter into agreement with Traxton Holdings for extension of Dix Roads and associated improvements. Bylaw 2026-07-035, administrative monetary penalty system. Bylaw 2026-07-036, amend parking bylaw 02-02-124 relating to the issuance of administrative monetary policies. And bylaw 2026-07-037 to enter into agreement with MLES for animal control and bylaw enforcement services.
All in favor? Carried. Council acknowledgements. Brian?
I had the pleasure of attending the opening of Valley Hair Artistry in the West End, and they've got a beautiful new location there, nice windows and area, and starting out with 7 chairs in operation, so looks good, and hats off to them. Most wish them all the success.
That's great. Thanks. I couldn't attend that, Brian, so I appreciate you going. I'd just like to comment on the multicultural event that happened in the city. I was brought greetings from council on the opening night. Very impressed with all that goes on there, all the vendors, the entertainment. 11 years in the making, they've got it down pat. And a lot of work goes into that as well as many events, and I thought it was really well done. Betty?
Hats off to Nevada I stopped by Stafford in the Park, and I see Jen had some friendly little people that she had to pass out some awards to, so I think they had some magnificent weather, and looked like it was a great success again.
Yeah, for sure. I was there as well, and yeah, great job by everyone there, and good choice on changing the date. The sun was shining. Okay, anybody else? Seeing none, motion to go into closed.
Yes, please.
Betty and Jennifer?
Moved by Councilor King, second by Councilor Gauthier, that the special council meeting of July 29, 2026 move into closed session at 6:35, chaired by Mayor Bennett, according to the Ontario Municipal Act 2001, 239.2, Section 239.3, and Section 239.3.1, in order to address a matter pertaining to a position, plan, procedure, criteria, and instructions to be applied to any negotiation carried on or to be carried on behalf of the municipality or local board.
All in favor? Okay.
Take 5.
Okay, take 5. Okay, back to open session. Motion
To come in, yeah.
to come into an open session, Alan and Betty.
Moved by Counselor Wren, second by Counselor King, that the regular council meeting of July 29, 2026 move back into open session at 7:45.
All in favor? Motion to
Adjourn.
adjourn. Brian and Wendy.
Moved by Counselor Ugly, second by Counselor Hewitt, that the special council meeting of July 29, 2026 be adjourned at 9:45.
All in favor? Carried. Thank you. Good night.